Welcome to Case by Case. This is a podcast brought to you by Floyd Zadkovich. This is Callum Chain. I'm Luke Zadkovich.
Every episode, we read a case independently of each other. We jump on the podcast, we hit record. So what you get is our raw thoughts on that law.
And we're super excited with some of the guests we've got coming up on future episodes. So keep an eye out.
And if you like the podcast, all we'd ask is that you hit subscribe and share with your network. Okay, let's get into it.
Let's do it. Welcome to Case by Case. This is a podcast brought to you by Luke Zadkovich and Callum Chain. We don't have Callum on today, but I'm delighted to welcome Matthew Harvey KC from Owen Dixon Chambers in Australia. Welcome, Matthew.
Well, it's great to be with you, Luke. Unfortunately, I'm not doing this in person with you, but the wonderful thing about technology means that we can talk like this across the world. So thank you so much for inviting me.
Oh, it's a real pleasure. And look, I know Callum gives his apologies. It was just a little bit hard to make the US, Europe, Australian time zone work at the moment. But in our field of shipping and international law, it's all par for the course, right?
Oh, absolutely. And I'm very grateful, Luke, that you don't have me up at 2:00 in the morning doing this, because I don't quite know how coherent and entertaining I would be. I'd probably be yawning a lot and looking very bleary-eyed into the camera.
Well, yeah, no worries at all. And look, I wanted to just give a little introduction. I've had the good fortune to actually get to know Matthew really well over the last year, 2 years on a case that we had together in the Federal Court of Australia. We hadn't actually worked that much before that case, so it's been great to get to know you. We had a lot of fun on that one. It's now concluded. For those of you who haven't come across Matthew, he's one of the leading KCs in Australia, has a particular focus on shipping, maritime law in Australia, but also does, general commercial law matters as well. But there's not many KCs who have that out and out focus on shipping law in Australia, I think it's fair to say. And so, yeah, it's been good to work with you over the last little while, Matthew.
Well, it's been an absolute pleasure. Unfortunately, we can't go too much into the case, but it was an awful lot of fun involving some very interesting parties, and I think we got a very good result, if I may say. So good fun and great meeting with you and working with your firm, which has been a pleasure.
Yeah. So perhaps I just thought I'd ask a couple of questions about, your background and starting really at the top. Like, how did you get into this area? Like, what was it about shipping that kind of dragged you in and hooked you, so to speak?
Well, look, I would love to say, a lifelong love of the sea, a mariner, all that sort of stuff, long studies at university, but none of that applies to me at all. The fact of the matter is that I was sitting in my master's chambers when I was very, very junior barrister, reading his briefs, and I'm struggling to get briefs myself, when my clerk called and asked me if I had anything on for Friday, because they had something in the Melbourne Magistrates Court involving shipping, and they asked me whether I was free. Yes, I was, and whether I knew anything about shipping, and the answer was no. But I said, but I'm very keen to learn, and I thought to myself, well, it can't be rocket science. And so what happened was I went off to Melbourne Magistrates Court, just down the corner here, and appeared in a shipping matter. And the extraordinary thing about that is that the people who instructed me in that matter are still briefing me today. One of them is very good.
You must have done something right.
Well, I don't even remember what I did now, but I learned a lot. I loved it, and just one brief led to another. And I developed a practice and, of course, a great love for maritime law. The interesting thing I've got to say, Luke, about maritime law in Australia, as opposed to our brethren in the UK, I'm not sure about other jurisdictions, is that I know when I come across English counsel, they say, "Oh, do you do wet work or dry work?" And my response is, we do everything in Australia. I can't afford just to do dry work, carriage goods by sea. I can't just afford to do only collision work, wet work. We do everything. So you do, carriage of goods by sea, contracts of affreightment, collisions, regulatory issues. You do the whole gamut, and actually rather enjoy being exposed to all these different facets of shipping law in Australia.
Yeah, and what kind of cases tend to get litigated? Do you find yourself dealing more with the bumps and scrapes, the casualty type cases, or are you in court more on, and indeed in arbitration, on contractual type issues?
Sure. At the moment, my biggest one is a collision which occurred down in Tasmania, a case named after the wrongdoing ship, the Goliath. That sort of collision work has never been a huge part of my practice, simply because we've never had that many
Yeah,
collisions down here. Most of my work has been carriage of goods by sea, so fights
right.
over bills of lading, charter parties, that sort of thing. And what I've been doing recently is looking more at doing more arbitration work as an arbitrator, but I've always done work as in arbitration as counsel, but nowadays doing it as the arbitrator. And I've done
Mm.
some multiple cases, generally on I've done one on salvage, I've done one on grounding. So, but most of them have been on charter parties,
Mm.
demurrage, detention, all those sorts of classic things that you find in arbitration.
And is that for arbitrations that may be seated outside of Australia as well, or on English law, or indeed Singapore law? I know you're quite active in Asia as well. If our listeners are considering arbitrator appointments, is it limited to Australia only?
No, it's not limited to Australia only. I mean, I started out doing only Australian ones because they were the only ones I could get appointments. But as I've pushed more and more into the near north of Australia, principally
Mm.
Singapore, I've found that I've picked up a number of arbitrations there as arbitrator. And
Mm.
English law applies, Singaporean law applies. I've had one where the debate was over Chinese, English, and Singaporean law.
Mm. Wow.
Parties tell you what the law is, and then you go ahead and apply it. But and that's what you do. So I mean, I will say this, and those of you who aren't Australians perhaps will think I'm arrogant, but a solid grounding in Australian law, and I think this would probably definitely apply to the Singaporeans and the English, means that you can pretty much do shipping law throughout the common law jurisdictions. I know that's a huge call, but it's not completely foreign. And I think there are obviously going to be differences between the jurisdictions, but it's not that hard to pick up those differences, particularly when you're saying to the parties, tell me what the law is,
Mm.
and you're being told what it is. So it's very rarely you have many debates over what that law might be.
Yeah, I think it's fair to say. I kind of recall my career and kind of the journey. I started off, as you know, and many of our listeners will know, in Australia, qualified there, worked at a firm now called HWL Ebsworth. It was just Ebsworth and Ebsworth in those days, in insurance. And so I cut my teeth on kind of professional indemnity and financial lines insurance cases, and some really, remember the HIH collapse and all the fallout, the Royal Commission and all of that. We were involved for one of the reinsurance brokers on that, for their primary layer insurer. Anyway, that's where I kind of cut my teeth, and then moved from there over to London, and joined what's now HFW, and moved into maritime and commodities and energy work. I was actually sat in the trade and commodities team, trade and energy team, but we did a lot of maritime. It was kind of, it just was such an integral part of it. But one of the things that I kind of, I had to build up my confidence in a new jurisdiction. I was a young guy, young associate, what have you, but I never felt like I'd had some inferior type of education or start in terms of a legal career. I really felt like I was well prepared, in both education, and also, cutting my teeth at the law firm I was at, and then moving over to the big international, London-based firm. And so, yeah, from a kind of preparatory perspective, and I have this conversation a lot. I lecture at my old university at Wollongong on a shipping course, and we often do a little bit of a kind of careers element to it, and I'll speak to the students about paths that are out there, and it really is doable, I think, from a transition perspective. But coming to your point on the nature of the law. Now, at the moment, I run an international practice where I have cases in England, cases in the US, cases in Australia, running sometimes in both jurisdictions simultaneously on the same case, one that's keeping me quite active at the moment. But it is really possible to kind of transcend borders in this area of law. A lot of the concepts are similar. You have international conventions. We're going to talk about them, talk about one of them today. And the concepts are similar. And so, yeah, I entirely share that view.
I mean, the concepts are similar. I suspect we all use the same books. I mean, Scrutton on Charter Parties, which is an absolute favourite of mine, is a classic. And that's just one of very many. I won't read out the books that I've got sitting here in chambers. But yeah, I mean, we use the same books. We read the same cases. I was just talking to you before we came on the air that we're talking about the CMA Flaminia case, which was decided a couple of days ago in the United Kingdom Supreme Court. In Australia, we're interested in that. And so there's this cross-pollination that takes place of interest that takes place. What's happening in different jurisdictions? I've had a case involving a collision I mentioned a little bit earlier. That's something that my friends, colleagues in Singapore are very interested in. The same with Hong Kong, and a case which also got mentioned in the Flaminia. So, I mean, it's one thing to talk about our own jurisdictions, but particularly in the private international law, we are all very interested within the common law world about what's happening in relation to shipping law.
And I think that's a really good segue, not by design, but I think it's shaped up that way for the cases we're going to discuss today. We've got kind of one main case that we're going to focus the discussion around, which is the Fimbank and KCH Shipping case, which was a decision from the UK Supreme Court at the end of last year, end of 2024. But what's interesting is that case references to Australian cases. And it might be useful to kind of go through a couple of those Australian cases and then see how these issues were dealt with by the UK Supreme Court. And, the segue that we've got here is that this case is dealing with the wording in an international convention in the Hague-Visby Rules and the Hague Rules before that, essentially a cargo loss regime for those that don't know about this. And this convention gets incorporated into contracts of carriage by sea, and it sets out some of the limits and the obligations on parties to those types of contracts, including the all-important time bar, which for any lawyer is one of the day one issues you face on any case. Make sure you know what the time bar is on your case. And so we're looking at misdelivery claims and whether there's a time bar, 1 year time bar in the Hague-Visby and Hague rules. And yeah, we've got a comparison here between UK and Australian law to kind of pull together.
Absolutely. I mean, today we're looking at Article 3, Rule 6, and I hope the listeners will forgive me, but I'm going to read a little bit of this out to them. But somebody to paragraph 6 bis, we don't need to worry about that. The carrier and the ship shall in any event be discharged from all liability whatsoever in respect of the goods unless suit is brought within 1 year of their delivery or of the date when they should have been delivered. So this is really interesting. You see that the words used there, discharge from liability, that's fantastic, but it's in respect of goods and it's about their delivery. Now, unfortunately, we talk about discharge in two senses, discharge from liability, but in the other sense, we talk about discharge of cargo from a vessel. And amongst the Australian cases that we're going to look at before we look at the Supreme Court case, there seemed to be some confusion over whether this clause or its precursor extended to just discharge from the vessel or whether extended to delivery. There's the point to be made, obviously, Luke, is that, a consignee is not going to be standing at the docks with their arms wide open, accepting the goods when they come off. The goods are discharged. They might sit around on the dock for a while or in a container yard for some time, and then they are delivered. And the question is does that contractual 1 year limitation stop at the point of discharge, or does it go on to the point when delivery actually takes place? And so that really is, in a nutshell, what this whole debate has been about.
Yeah, exactly. And if we just go back a step from there, the nature of the claim or the types of claims we're talking about here are misdelivery claims. So that's a phrase that you and I know really well, but for those that don't deal with misdelivery claims day in, day out, what we're talking about here is when a cargo owner is at the destination end of a voyage. They've been provided a title document that says they are the cargo owner. Typically, that'll be the bill of lading. They're holding on to the bill of lading, and they're at the other end wanting to get their goods off the vessel. And lo and behold, the vessel owner, those on board the ship, have delivered the cargo to someone other than the holder of the bill of lading, someone who should have got the cargo. And there are all sorts of ways that a misdelivery claim can arise. It could be a ship-to-ship transfer. It could be done through a warehousing arrangement. It could be just a straight discharge over the ship's rail to the dock. But the point is, the misdelivery is it's being delivered to the wrong party. And then the party who is holding the bill of lading, that could be a receiver of that cargo in the sense of someone who actually wants those physical goods, or it could be, as we have in the Supreme Court case, the Fimbank case, a bank who is holding on to the bill of lading as security for it getting paid. And so the bill of lading that serves as the bank's security makes it the cargo owner if it steps in and exercises its rights as the holder of the bill. And the bank, in this situation, went to the cargo and said, well, where's my cargo? It wasn't there. It was delivered to someone else. And so they then bring a misdelivery claim under the contract of carriage against the owner of the ship, saying, you didn't deliver the goods to me and you were supposed to do so. What we're talking about here then is there a time bar that is incorporated into that contract of carriage by virtue of this international convention, and there have been different versions of that international convention, the Hague Rules and the Hague-Visby Rules. There's another set of rules since then, which we won't go into for the purposes of this discussion. But the question is, in that international convention, there is a stated time bar, which is what Matthew's just read out, and we're looking at what's the scope of that. Does that include misdelivery claims, or are there limits on the scope of that time bar as set out in the international conventions? And it's really interesting because there hasn't been a kind of clear-cut, uniform answer to this. When you read that out to me, my initial response is, wow, that sounds very broad. so I don't know about you, but that's my initial reaction. I know we can get into the detail of why, but yeah, on first blush, I'm like, that's quite an exhaustive clause.
Yeah, no, you're quite right. Misdelivery, of course, misdelivery can be to the wrong person, claiming to be the consignee, but also you can have misdelivery in this sense. You've got a seller who will be called the shipper on the bill of lading. The carrier is the shipping company, and the consignee is the person who will ordinarily take the goods. But the consignee can only take the goods if he, she, or it has the bill of lading in its hands and can hand it over, an original, to the owner of the vessel, the carrying company. If they don't present the bill of lading, but the carrier hands the goods over to them, there is a misdelivery, because the person who actually is entitled to receive those goods is the holder of the bill. And if you're a purchaser and you haven't paid, and this is what crops up in the two Australian cases, if you're a purchaser who has not paid, and therefore you don't have an original bill of lading to show to the carrier, you're not entitled to take delivery of those goods. And most importantly, the carrier should not hand over those goods to you without an original bill of lading.
Yeah, absolutely. So why don't we do this? Why don't we get into the Aussie cases and give a summary of those and just unpack them a little bit? I don't think we need to spend too long on them, because I think that then sets the scene for the Supreme Court recent Fimbank decision. Do you want to start with the China Ocean shipping matter or the Camel export?
We'll start with the Chellaram case because the China Ocean case,
Yeah.
because that's the first in time, and this is the New South Wales case. The Victorian case then reflects upon it and takes a different view, which is interesting in itself. In the Chellaram case and China Ocean shipping, what we have is Chellaram's Hong Kong company selling 900 cartons of blank cassette tapes. Luke and I know what cassette tapes are, and if you're younger than us, you've got no idea what we're talking about. But I think they're audio tapes. By the way, we once recorded music. That sold
They were the
900.
good old days, when you used to put together a mixtape for your girlfriend to show you, that you had some good tunes, and you thought, I used to think I was so cool with my Walkman, like on this.
Exactly.
Anyway.
Bit of nostalgia for the older listeners out there. The young ones are probably still scratching their heads. But anyway, Hong Kong company sells 900 cartons of blank cassettes to Jemson, which is an Australian company, for a very small sum, 235,000 Hong Kong dollars, which is back in those days quite small. They're packed into a container. They're loaded onto a COSCO vessel for carriage to Sydney. COSCO issues a bill of lading. Chellaram is the shipper, not surprising. The consignee is to order. That's perfectly normal. It's for the bill that can be negotiated. And then we've got a notify party, which is Jemson, which is all entirely above board. The goods arrive in Sydney. Jemson asks COSCO's agent to release the goods without the bill of lading. Jemson gives an undertaking to the agent. The agent assumed it was authorised to receive the goods without production of the bill of lading, and so it hands them over. And what happens is that undertaking, or that indemnity, is worth nothing because Jemson goes insolvent. It never pays for the goods, and it's a disaster all round. What happens is that, and I'll very briefly deal with Chief Justice Gleeson and Justice Samuels, who agreed with him. They decided the question about the time limitation, because the issue here was that the case was brought against China Ocean more than 12 months later. They decided on the basis of that term on the back of the bill of lading, which was a 9-month limitation, as being applicable. They did not look at the Hague-Visby, the Hague Rules rather, as they existed at the time. Justice Kirby, he took a different view. He focused on the Hague Rules, and he noted that they are extremely wide, and talked about the fact that it refers to delivery under the bill of lading. Now, what was happening there is that the respondent said these rules only apply up to discharge from the vessel. You get protection only up to discharge. What happens thereafter, including delivery, which up to delivery, I should say, is not protected by the time bar. And can I say,
Can we just pause for a moment there? And sorry to interrupt you, Matthew, but I think it's important to kind of double tap this concept. And sorry for the slight tangent on the findings of Justice Kirby. But this concept of discharge and delivery is really important in these types of cases and in other kinds of cases. Discharge of cargo is when it is physically coming over the ship's rail, and the cargo is coming off the vessel and being loaded either on a dock or another ship, or being taken hold of. It's something to think of in a physical sense. Delivery, it can happen at the time of discharge, but it can also happen at other times, at a later point in time. Goods may be discharged from a vessel and put into a warehouse, and delivery doesn't actually take place until someone comes along with their bill of lading and says to the warehouse company, here's the bill of lading, the goods are in the warehouse to the custody of the vessel owner, and the vessel owner says, yeah, okay, you can release the goods. Delivery may then happen at that later point. So discharge and delivery can happen at different times, and delivery is, if you like, almost more of a legal kind of concept. It's happening at the time the goods are becoming, they're being transferred or titles passing. It's a slightly different concept. So, and that comes up in these cases, doesn't it?
Oh, absolutely, absolutely. With the Chellaram, you've got them in a warehouse. In the next case, they're in a bonded warehouse waiting for delivery. So they've been well and truly discharged. It's just the question of then effecting delivery some other place, usually on the wharf or in a container yard or a bonded warehouse, at a later time, a day or so or longer after the goods have been discharged from the vessel. So that's what you've got. Now, interestingly, Luke, you focused on the words of Article 3, Rule 6, and you said, gee, they're wide, and they are wide. And that's, in fact, the very first thing that Justice Kirby focused on when he read that the provision and said it's very wide language. He looked at it in its context, and the evident purpose is to govern incidents of carriage of goods, sea carriage of goods. He looked at the practical implications of interpreting it in a very narrow way. He thought that was unattractive. And finally, and this for those of you who are real contract nerds, and I think Luke and I are probably guilty of this.
Guilty.
It raised a really interesting issue of not allowing, as he said, through the side door, the discredited doctrine of fundamental breach. Now, for those of you who do not know, the younger ones probably don't know much about fundamental breach, but back in 1967, the House of Lords decided a case called Swiss Atlantique, where they said that no matter how widely expressed an exclusion clause may be, if the wrongdoing contracting party has committed what they described as a fundamental breach of the contract, they cannot rely upon the exclusion clause. Now, that was ultimately overturned. I have to quickly check my notes. In 1980, and again by the House of Lords in a case called Photo Production and Secure Accord Transport. In Australia, we had a case called Darlington Futures and Delco decision at the High Court of Australia, which comprehensively said, no, exclusion clauses should be interpreted like any other clause. The doctrine of fundamental breach does not apply. And that is what Justice Kirby is referring to. Why am I talking about this so much? Because it actually still seemed to have some life in it, this doctrine, in the next case that we look at. But let me just quickly finish off. It's imperative in this case you realise that Justice Kirby says that the Hague Rules are not confined in operation to events strictly limited to events rising out of loading to discharge. He took the view that it could also extend to point between discharge to delivery, and therefore misdelivery, as occurred in this case, was capable of being covered by the 1 year limitation.
Okay. Now, before we move off this case and get on to the Camel case, I did want to just read out a section of Kirby's reasoning, which was then quoted in the Fimbank case, which we're going to come on to, so in the UK Supreme Court. And I'll just read it verbatim. It says, the suggestion that the Hague Rules, and in particular Article 3, Rule 6, should have no application to events occurring after goods go over the ship's rail and are discharged appears on the face of it unlikely, given the purpose of the Hague Rules to govern incidents of sea carriage of goods. The argument is doubly unattractive when the very wide language of discharge from liability, referred to in Article 3, Rule 6, is considered. It is most unattractive of all when consideration is given to the practical implications of so holding. And what I really like about that, if I can say that about such an esteemed justice's language, is that this frames pretty much the judgment of Lord Hamblen in the Fimbank. The points that Justice Kirby have gone to almost set out the key linchpins of that decision that we're going to go and unpack. And we'll talk about each of these in some more detail, but it kind of encapsulates it's almost the roadmap for then how the Supreme Court deals with it.
Oh, look, I agree. Justice Kirby was ahead of his time in some ways in the way he went ahead and interpreted this. The sticking point in Australia is that the Supreme Court, and I should say the full court, as it was in back of those days, the full court of the Supreme Court of Victoria, which is nowadays our Court of Appeal, in the Camel case, decides the opposite. And they look at what Justice Kirby says, and they say, no, the Hague Rules, as they then stood at the time, only apply from loading to discharge. Anything that happens between discharge and delivery is not covered by it. And the way they got there, and perhaps I should just say, the cargo in this case is a quantity of cheese and butter going from Melbourne to Guam. The bill of lading, the two bills of lading, well, three, we don't need to go into all of them, but we've got Camel is the shipper, the consignee or notified party is Michael J. Charnowski Co. in Guam. It's a Guam company. Goods get to Guam. Charnowski hasn't paid. He knows the lady at the bonded warehouse. He says, "Don't worry, I'm going to pay. It's all fine. I'll front up with the bill of lading." That's what he says. "I'll front up with the bill of lading in due course." She hands over the goods to him, and what do you know? He never turns up with the bill of lading. And so the claim is brought by Camel against the carrier, which is NPL Australia Proprietary Limited. Really interesting thing about this one, Luke, and I'm sure you've noticed this, it's a fight over a few thousand Aussie dollars, progressively getting less and less as exchange rates work against us. It was decided in the Melbourne Magistrates Court. Proceeding was commenced more than 12 months after the goods had been delivered, so the time bar looms large. The magistrate decides that you are time barred, that you're not time barred, rather. It then goes before a trial judge in the relatively early days in his life on the Supreme Court called Justice Hayne. And those of you who know a lot about Australia will know that Justice Hayne ends up becoming a very eminent judge of the High Court of Australia. And he takes the view that the time bar does apply, and so he disallows the claim. And what then happens is that Camel then goes to the full court of the Supreme Court of Victoria and goes before three very eminent judges, Justices Marks, Fullagar and Ormiston in that court, who look at what Justice Kirby said and took the view that they weren't going to follow that, and they decided that the time bar was limited between essentially ship's rail to ship's rail from loading to discharge and would not go any further than that. And the reason was, as I said a bit earlier, talking about Swiss Atlantic, is that they took the view that although that had been disapproved, there was some sort of semblance of it still existing in Australia at the time. They looked at Darlington Futures and Delco, which really did sweep it aside. They felt there was something still in fundamental breach. And what they did was they said, essentially what you're asking us to do is to excuse fundamental breach by interpreting this clause or this rule in the Hague-Visby Rules as widely as you contend. We're not prepared to do that, and they did not.
Yeah, it's really interesting to see that divergence in approaches to this type of issue, and it does set up kind of the issue here. I think the cases, and there's a case in Malaysia as well,
Yes.
that the appellants were relying on here to argue that the time bar doesn't apply. They go to this argument that the Hague and the Hague-Visby rules have a period of responsibility where the rules cover from the moment of loading to the moment of discharge, and that's it. They don't seek to regulate the situation before loading or after discharge. And the Camel case and the Malaysian case, they go down this kind of line of argument, and indeed that is the crux of the appellant's argument in the Supreme Court in Fimbank as well. And what's really neat, I think, is how the Supreme Court ultimately deals with that issue. And we've got Lord Hodge, Lord Sales, Lord Hamblen, Lord Leggett, and Lord Richards, with Lord Hamblen giving the judgment here with the other lords all agreeing unanimously, where they deal with this issue of period of responsibility and look at the rules in their entirety and say, well, are there aspects of these rules that seek to go beyond the period of responsibility? And there are. There are different aspects of the rules which can be interpreted as regulating the rights and obligations between carrier and cargo interests, which is what this convention goes to, that sits just before loading or just after. The concept of exercising due diligence as to the seaworthiness of a vessel prior to a voyage. Most of the facts and steps that will be taken are before loading in that situation, right? That is one of the key provisions in in the Hague-Visby Rules. And there are a number of others as well. And so the court looked at it, well, yes, there is a period of responsibility. And yes, certain provisions of these rules limited to that period of responsibility. But does the particular rule that we're looking at here, does it fall within that period of responsibility, or is there a case to be made that it can extend to any claims arising, whether within this so-called period of responsibility or outside of it? And the court keeps coming back to that, and it kind of starts from the proposition that there are other types of claims that can arise outside of that period of responsibility under these rules. So, well, what does the time bar say about them? And then it goes to look very closely at the language of the time bar, the purpose, the object, what would be the consequences if there wasn't a time bar on misdelivery claims, and so on and so on. What did you make of that? What did you make of that period of responsibility point?
No, I agree with you. I mean, as soon as you were talking about a period of responsibility, I was thinking about the due diligence that a carrier needs to undertake in order to ensure the ship is seaworthy, arguably cargo worthy. But then there are things that take place after. I mean, at the end of the day, perhaps I'm being, as a black letter lawyer, I'm attracted to the argument, well, what do the words say and what do they say in their context?
Yeah.
And that is precisely the path that the Supreme Court goes down. I think it's the most certain path to go down.
Yeah.
And that's where I think it gets Lord Hamblen, and I said this to you earlier, Luke, before we went on air, in an absolutely tremendous judgment, can I say. He's a great writer, and arguably, and I hope I'm not offending any other of the lords sitting on the Supreme Court of the United Kingdom, but he really would have to be one of the most impressive shipping judges that sits on that court at the moment. So a great judgment from him. Perhaps it's worth just backing up a little bit and saying that in this case, we're looking at about 85,500 metric tonnes of coal being carried on the respondent's vessel, the Giant Ace, from East Kalimantan in Indonesia for discharge and delivery at Indian ports. It's pursuant to 13 bills of lading. They incorporated the Hague-Visby Rules. Cargoes are discharged by the vessel at 2 Indian ports against a letter of indemnity without production of the bills of lading. The actual holder, the so-called lawful holder of the bills, is in fact Fimbank. We don't need to go into why it's there. It's because of the financial arrangements and background. And it says, you should not have handed over these goods to these people. I hold the original bills. You should have handed them over to me, and claims that misdelivery took place after discharge. In this instance, again, there is that issue of the time bar, and the time has passed. And so then the question before the court is, well, what does, just make sure I've got the right one, Article 3, Rule 6 of the Hague-Visby Rules, what does it mean? Does it extend beyond discharge to delivery? The really interesting thing, I think, is, and it's exactly the same as the law in Australia and probably throughout our common law world, is how does one properly interpret Hague Rules, Hague-Visby Rules? And there's an important case our English listeners will know called the CMA CGM Libra, which sets out a number of provisions. First is that international convention should in general be interpreted by reference to broad and general principles of interpretation rather than any narrow domestic law principles. The second is that Article 3.1 of the Vienna Convention on the Law of Treaties requires that one give ordinary meaning to terms in their context in the light of object and purpose. The third is Article 32 of the Vienna Convention, same Vienna Convention, is that travaux préparatoires can be used to confirm a meaning or resolve the ambiguity. Now, it might be worth just mentioning what travaux is here, Luke. Travaux basically are the working papers, discussions that take place before the actual agreement on a convention. And so in this instance, what you'd look at is what were those reports, speeches, agreements that were reached in the course of making the Hague-Visby Rules. That's what we would call the travaux, and that they're often available, freely available to people. Find them online nowadays, which is even better still.
Yeah, and also on that, I think it's worth just pausing on how international conventions come to be, right? They're a matter of negotiation. You have different interest groups, different nation states putting submissions in. You have different industry bodies that are consulted, and this convention originally was brought in. So the Hague Rules in the first installment was brought in to kind of balance up, what was an imbalance between the powerful carriers on one side and cargo interests not having the ability to kind of get reasonable contractual terms against the carriers. And so, there was a public policy international interest in leveling the playing field between carriers and shippers and cargo interests. The way that these documents ultimately are agreed is, it's done over years often, and there's submissions made, and there are issues of what about this and what about that. There are drafts, and then ultimately there's the final document that gets signed off and then is ratified by nation states. And one of the first point that you made there, I think, is an important one, and that is that when any individual nation is interpreting, construing the language of the convention under its own law, so in this case under English law, we talked about some cases that would look at it from an Australian law perspective earlier, but they're looking at it not just from the perspective of what do we think from an English law perspective. Regard is had to how this would play out in the international field, and that's why there's much more around purpose, object, history, preparation, almost like a purposive type analysis, when English law contractual interpretation these days is much more literal. It's going more and more towards what do the plain words mean. And of course, that is the number one point here in an international convention as well, is to look at the actual words, and we'll come on to those in a minute. But there is more kind of contextual analysis that goes on when you're looking at an international convention for those types of reasons.
I mean, and that really ties in nicely into the fourth point that is made, was that it might be appropriate to have regard to the French text. If that is the official and authoritative version, one would look at the French text. So I don't know how good your French is, Luke. Mine's very much my schoolboy French. Thankfully, we have Google Translate to help out blokes like you and me, I suppose. But we might have regard to that. And then the fifth.
Well, Callum's got a bit. He's not with us today, but Callum, he dabbles in French. So
good on him. And the final point is there some sort of international consensus within the companies who have signed up to the particular convention? And if there is some, then a lot of store will be placed in that. So that was sort of the roadmap of where Lord Hamblen went in putting together his and ultimately reaching his decision. So the first one, Luke, the most important one: what do the words say in Article 3, Rule 6? What is the ordinary meaning? And you said,
yeah, exactly. And that's, I think, it's worth going through the provision again. I know you've read it already, but let me just go through this. It's in any event, quite a wide opening there. The carrier and the ship shall be discharged from all liability, another broad couple of words, in respect of loss or damage. In respect of is also broad language. It's not just loss or damage. It's in respect of loss or damage. Unless suit is brought within 1 year after delivery of the goods or the date when the goods should have been delivered. So, yeah, just unpacking some of those. In any event, that indicates that the time bar is to apply in any and every case. That's supported by the French language, I think, that's used on that, en tout cas, and that also suggests that it's quite a broad introductory language to this clause. The second point, all liability. This indicates that the time bar applies to any liability, however it may arise, and is not limited, for example, to liabilities arising under the rules. So that's interesting. There's this kind of broader purpose to it, if you like. The third set of terms to kind of identify is that it does not refer to loss or damage to the goods, right? Not just to loss or damage of the goods, but to claims in respect of loss or damage. And so that opens it up, as we know, to claims that are beyond just physical loss or damage. So if it was just loss or damage to the goods, that would, you think of only physical loss. But once you have in respect of, then that opens it up to financial loss and that are related to the goods. And then finally, when you look at the effect of the time bar, it then refers to all liability is discharged. There's this concept of finality and broad liability that's being discharged by this clause. So that's where the court kind of starts. It looks at the actual words of the clause and says, it's quite a broad clause.
Exactly. So once they look at broad meaning, what do they then look at? They look at the issue of context.
Yeah.
And they point out that this rule appears in a larger rule which focuses on what is to happen to and from the time of delivery of the goods. What is to happen at and from, rather, the time of delivery of goods. And as they say, in many instances, delivery will take place after discharge. And the view taken was that the rule recognises that there is a difference between delivery and discharge. Delivery is the transfer of possession. Discharge relates to a physical operation, they say, of actually taking the goods off the ship and putting them down on the side of the wharf. And so the point to be made here is that the rule is not to be read in its context as being narrow. It's in a much wider rule around it in its context, but also the rule ultimately, or in the context, there is definitely a distinction that's drawn between delivery and discharge. They're two different things, and we go back to what the words of the actual provision say. It talks about delivery should have been delivered, and so we can't, as it were, conflate the two things and put them together, and delivery and discharge one of the same thing. No, they're treated differently. Look at the context, and that takes you to that point.
Yeah, and it's in this section of the judgment, in the context section, that Lord Hamblen goes to the appellant's submissions on period of responsibility. And this is really the key argument for the bank. And they want to, as I said before, they want to argue that period of responsibility is from loading to discharge, and that the time bar should be read within those limits and not outside of it. The way the court kind of deals with this is it goes through to say, well, I agree with a lot of what Mr. Smith, who was appearing for the appellant, submitted on this, and the court agrees that the Hague Rules set out what has been referred to as this period of responsibility, during which the carrier is subject to minimum responsibilities and liabilities which cannot be reduced, and entitled to maximum rights and immunities set out which cannot be increased. So yes, the Hague Rules, and more so, if you like, than the Hague-Visby Rules in a way, it really does go to this period of responsibility point. So he accepts that. But what he doesn't accept is that this concept of a period of responsibility is to be read over the top of Article 3, Rule 6.
Absolutely.
Lord Hamblen says that it's clear, for example, that Rule 6 is concerned with the period up to delivery, including events which occur after discharge. So there's not this kind of stopping of the time bar at the time of discharge. It does deal with issues all the way through to the point of delivery. And what are we talking about here? We're talking about misdelivery claims. So if something goes wrong and the proper receiver, the proper holder of the bills doesn't receive the goods, they're delivered to someone else, that is an issue that's arisen prior to delivery. And so that does fall within the relevant rule here. So the court looks at that. For those that are interested, if you want to look into this in some more detail, that's in the purpose section. But then the court goes on to deal with in the context section. Then the court goes on to deal with some of these other points as well, which by this time it already feels like the race is run and won and run and lost. But the court does go through thoroughly and look at the other aspects like the object and purpose. And did you want to touch on some of those?
As far as absolute, I'll be as brief as I can. Object and purpose. As I said, the main object and purpose of Article 3, Rule 6 is finality. And it ensures that if something has taken place, there's a period open by which you can have to look into the events and what's taken place. But once the 1 year time bar has passed from delivery, as they say, the accounts or books can be closed. And that's the finality. That is the purpose as Lords saw it. Lord Justices saw it. And so in those circumstances, they felt that that was the purpose. And in those circumstances, it needed to be read in the context of that purpose. As far as the Trevo is concerned, we've been talking about Trevo. Trevo was unhelpful. Can I say, in so many of the cases in which I've appeared where I've had to look at Trevo, and for that matter, second reading speeches in Parliament, I've almost always found it to be unhelpful. But
it is almost the nature of the beast, right? The whole point of these second reading speeches and particularly in the international context like this is that there is this lobbying going on and there's this back and forth, and it's not necessarily going to be exactly clear in the process of formation of the convention what exactly the convention then means. It's why if you draw a comparison with contractual interpretation, courts are very reluctant to look at what the parties were saying in negotiations. They want to know what they finally agreed on and what the words of the clause say in the contract, not what the parties were trying to get or they were edging towards or what they thought the contract said. And it's a little bit like that. It's not, the analogy is not perfect, but there's a little bit of that. And I think that's, that kind of informs what you're saying there in a way.
Oh, yeah. I mean, the classic one is where you get the debates are part of the Trevo. And, Mr. Zadkovich, on behalf, representative of the United States, he says that the word finality should not be used, and it should be the word lastly. And Mr. Harvey from Australia says, no, it should be finally, not lastly. And so the thing is that you look at that and you think, well, how does that assist me in determining what this means? Australia and the United States disagreed through their representatives. So what?
Yeah,
so
exactly.
That's one of numerous reasons why Trevo, I think, is often unhelpful. I wouldn't be pitting my hopes too much on Trevo unless it's really clear. Of course, like everything in the law, it depends. But so far in my travels looking at Trevo, I've found it to be unhelpful. I hope one day to find it where it is helpful.
Yeah, well, it depends on what you're arguing, right? Which side of the debate you're on.
Absolutely. Absolutely. We are after all.
Yeah, exactly. And then the court skips through some of the English authorities looking at Rule 6. And this is really to emphasize that the cases that have looked at this phrase in other contexts, but still interpreting different parts of the relevant rule, have found it to be quite a broad clause. And so, that's the kind of, and there's some specifics to that, of course, but that's the general takeaway from the English authorities section, is that, those cases that have looked at it have found it quite broad. And then it's in the international case law section. We've touched on those already. That's when there's the comparisons with Malaysia and Australia. And indeed, my takeaway from this was that there wasn't a kind of groundswell of contrary views on this. Yes, there's a case in Malaysia. Yes, there's one case in Australia that can be read against the way that the Supreme Court wanted to go with this. But it's not like it was swimming against the tide in terms of international consensus on this issue. And if there was a big body of work outside of law, outside of England, that had decided this in a contrary way, there would be much more reluctance, I think, from the English court to just put that to one side and come to its own view. It would weave that in and look very closely at the reasons. They then pick up, of course, on the Chellaram decision, which we talked about before, and Justice Kirby's kind of point there. So yeah, that's kind of the nub of it, and the court finds not only that the Hague-Visby rules and that the time bar applies, but also for the Hague rules as well. And I think there was perhaps some hope that on the Hague rules the appellants might get through, but on the Hague-Visby, but the court went that both have on this key issue of whether the time bar is cut off by the period of responsibility. That doesn't change in the Hague and the Hague-Visby rules. That issue, it doesn't differ between the two versions of the rules. There's nothing that really changes that. So once the court found that, well, the period of responsibility doesn't clearly deal with the language of Article 3, Rule 6, then it kind of followed on both fronts.
Yeah, that's right. And so ultimately we're left with the answer, for those of you who want an answer to all this, is that claims for misdelivery of cargo occurring after discharge have been completed are covered by the time bar in Article 3, Rule 6 of the Hague-Visby Rules and its precursor in the Hague Rules.
But isn't that ultimately what the court wanted? We haven't talked about that much. But isn't one of the guiding points in all this, and it is touched on in the judgment, that it would cause chaos if parties had to go through and finally distinguish, does this claim arise at the point of discharge, sometimes just after the point of discharge, but before delivery? And if it's there, one time bar applies, but it doesn't apply if it's after discharge. It would just lead to a whole lot of complications. And often courts will like to adopt a position that makes things clearer, simpler, and lead to less litigation. And that, to me, is a real kind of North Star on this judgment, is that, as you just said, the position can now be encapsulated in one sentence.
Oh, absolutely. And can I say, English, Australian law are very, very similar, but one of the things that you do see more so, ever so slightly more so in English law, is a greater emphasis on certainty of outcome. And so if that's what the words say, that's what they say, and we will apply them. In Australia, we do the same thing, but sometimes we sort of think, maybe that's not quite what the justice of the situation determines or should determine. We will put a slight spin or slight gloss on it. But I've got to say, that's very unusual. But one thing that's always stood out to me about the English cases is this emphasis on certainty. And I think it is the right approach. And if people are unhappy about it, Luke, the easiest thing to do is just go ahead and change the legislation or the convention or whatever you want to do. But common law should be clear.
Good luck.
Oh, absolutely.
Good luck. Look, I think you're right, Matthew. And yeah, look, thank you for taking, giving us your valuable time to talk this through with me, and for our audience. I hope they've enjoyed the discussion. If they've gotten this far, then they've hung in there for an in-depth look at this topic. And yeah, if you have any questions on this or any follow-ups, I'm sure Matthew and of course for me, we'll be happy to field any questions. And if you have issues that arise in Australia, you've got someone that you've been introduced to now. So thank you for listening in. We'd be delighted if you liked, subscribed, and followed the podcast on your favorite channels. All those things really help the podcast to develop. Other than that, thank you, Matthew.
Well, Luke, thank you very much. And for those of you who were not privy to the conversation Luke and I had, we are both flat shat at the moment. I've got to go off and get a judgment shortly. And Luke is up to his eyeballs, if I may say, Luke, in what sounds like a fabulously difficult, wide-ranging case. So it's been great having this little moment to talk about law and to give vent to our nerdish tendencies to talk about law. But we must get away and start earning some money.
Yeah, let's get back into it. All right. Thank you, everyone. Until next time, take care.
Bye-bye.